Hello and welcome to our webinar today, Immigration Services, Getting It Right for Your Vulnerable Clients. And thank you for everybody for joining us. My name is Richard Silver. I'm a Policy Associate at the Solicitors Regulation Authority. We'll probably refer to ourselves as the SRA from here on in, and I'll be chairing today's session. So as well as being broadcast live, the webinar is going to be available to rewatch or share as well with any colleagues, and that will be available from the SRA's YouTube channel. We'll also share the slides that we'll be using today and any links to resources that we refer to as well on the web pages for the event on our website. We've had a quick look to see who's joining us today. I'm delighted to say that we've got people from all sorts of different time zones, some international vibe going on today, which is fantastic. So even though we regulate solicitors in England and Wales, we've got some international perspectives in terms of viewers today. So thanks for staying up or for getting up early, whichever the case may be. Thank you also before we start to anybody who's been able to send us any questions in advance. We're really grateful for those. We should have some time towards the end of the webinar today to pick up on some of those. If you're watching this live as well, then you can continue to submit questions as you go along. You just need to click on the question link, which is below the video, and you can submit your name or anonymously as well. Just a quick mention as well in terms of the scope of today's webinar. It isn't an advice clinic necessarily, so there aren't any opportunities today to look at specific issues or specific cases. However, we are going to be looking at the types of information and support that are available for practitioners in this area, but we won't be able to get into any specific circumstances. So today's webinar, we're looking at a really important area of our work. So this is how we regulate immigration work and how people can be supported who are actually doing that work and providing immigration advice and representation to some of the most vulnerable people in society. I'll just mention what we're going to be covering today. So we'll firstly be running through some of the key findings from the SRA's recent thematic review of immigration firms, and some guidance also that we've introduced in response to findings from that review. We're then going to be taking you through our new guidance on effective supervision of individuals who deliver legal services, and that's particularly relevant to this area and to this subject today, and we'll explain a bit more about why that is. We're going to be hearing as well from one of our key partners in the immigration sector, the Office of the Immigration Services Commissioner, and we'll refer to that organisation as the OISC for short as we go forwards now, and they'll be talking about the good practice that they've identified through their work. And then finally, we'll be hearing thoughts and reactions in this area from the perspective of solicitors as well. Before we begin, I'm just going to quickly mention our main speakers today. So firstly, we're delighted to be joined by Deirdre Gilchrist, the Head of Regulation at the OISC, and responsible for the development and maintenance of the OISC's regulatory framework. So this includes the application processes for organisations seeking registration, procedures for ensuring advisors within the scheme remain fit and competent, and also the investigation of complaints and enforcement action that may be taken against regulated advisors. We also have Julie Moqtadir with us today. So Julie is a trustee for the Immigration Law Practitioners Association, or ILPA, and also a partner and head of faith sector at the law firm Stone King. Julie is an experienced immigration solicitor and has worked in this area for many years, advising on a broad range of immigration issues, including UK organisations recruiting from abroad and matters affecting European nationals employed in the UK. She uses her knowledge of often sensitive immigration-related matters to support clients across sectors, so some really valuable insights there. We also have Helen Morris with us today on the call. Helen is a regulatory manager at the SRA. She's leading our work on a thematic review of immigration and produced the report that we'll be discussing shortly. And last but by no means least, we also have Tony Stafford, who is a policy manager at the SRA, and Tony led the work to develop and produce our guidance on effective supervision. So that's who we're now going to hear from. And as I mentioned, we should have some time towards the end of the webinar today to pick up on a few questions as well. So with no further ado, I'll hand over to Helen to talk to us a bit about the thematic review and the things that we found.
Thanks, Richard. I'll start off by explaining a bit about the thematic review itself before going on to discuss what we found, including some examples of good practice. So the purpose of a thematic review is to allow us to better understand any challenges there may be in the sector and then consider the extent and impact of any concerns. This review, as with all our thematic reviews, also gave us the opportunity to look at current or emerging risks. Our thematic review was published at the end of last year and was based on data gathered from a range of sources. Initially, we engaged with several key stakeholders, including the Law Society, the Legal Ombudsman, and the OISC, who's on this call today, to gather their views on the sector generally. We then engaged with 40 law firms, initially holding an online meeting with a head of department, before then visiting 38 of those firms to speak with a head of department and a fee earner and review 2 of the files. These firms were of various sizes, including sole practitioners, and some did legal aid. We looked at this area because users of immigration and asylum legal services can be some of the most vulnerable in society, and it's likely that many will have experienced stressful or difficult circumstances and have little knowledge of the UK's legal system. Like all users of legal services, though, it's important they can access good quality legal advice so they can get to the right result quickly. The impact of bad advice can be particularly severe in this area, and it can be difficult to put right. For example, a client could potentially be returned to a country they felt compelled to leave. So what areas did we look at and what did we find? And if I could have the next slide, please. So the review focused on 3 main areas. The first area was the quality of services provided, and we were interested in seeing whether firms delivered a good quality service and how they did this. We looked at how they engaged and supported clients to understand the legal process, especially if those clients were vulnerable. Overall, we were satisfied with the quality of service being provided. We were also pleased to find that with more hearings being held online, that firms had also considered the practicalities of these for clients. So, for example, setting up an appropriate space in the office for clients to use and updating any hardware or software where necessary. When it came to discussing the strengths and weaknesses of a case, most fee earners told us they did this verbally with a client. Having these discussions is obviously important to make sure that claims without merit aren't being pursued. It's also important that fee earners continue to reassess the strengths and merits of a case as it progresses. However, what let some firms down was not keeping a record of these discussions on file. We consider it good practice for firms to do this and to send clients written confirmation of what was discussed. Clients can then review and reflect on what was discussed and the advice given. One example of good practice we did see was a firm standard letter to the client that contained a section titled Actions You Agreed to Take, which clearly set out what the client needed to do next. The second area we looked at was supervision. We were interested in understanding what solicitor supervision looked like in practice and how firms evidenced that supervision had taken place. From a client's perspective, good supervision is important because it gives them reassurance that their matter will be progressed and gives them confidence in the services they receive. Effective, regular supervision can also help firms and individuals identify any learning and development needs, which is an important part of our continuing competence requirements. Having an effective supervision system in place is also important to make sure firms comply with their regulatory requirements and any requirements under the Immigration and Asylum Act. This is particularly important where a person provides services on behalf of or under the supervision of a qualified person. It makes sure that whoever deals with the matter is competent and has sufficient capacity, and that can be especially important if the firm uses outside consultants. While most firms told us that supervision was taking place, unfortunately, they couldn't always evidence this. It's really important that firms can do this, especially considering that most firms are now relying more on technology. So for example, if your fee earners are working remotely, you should make sure that the file is a true reflection of the whole matter, including any supervision which has taken place. As well as day-to-day supervision, we also found that most firms carried out file audits, and this proved to be a useful way to check the quality of work and that matters were being progressed. However, it is important that your staff understand the purpose of a file audit and that the outcome and any recommendations are communicated to the fee earner. In relation to training records, unfortunately, we found that a significant number of fee earners did not keep an up-to-date record. While it's not mandatory to have a training record, it is an easy way for fee earners to demonstrate how they are meeting our competence requirements. The third and final area we looked at was complaints, and this included looking at the firm's own complaints information, as well as the duty to report serious misconduct to us. Unfortunately, a few of the firms we did visit did not provide sufficient complaints information. So firms should check that they are providing information about how to complain and that this information is accurate and follows our rules and guidance, as well as being written in plain English. It's also important that solicitors provide clients with reassurance that if they do make a complaint, it won't impact their case and there won't be any legal repercussions to them personally for making that complaint. We did identify some good practice in this area. Fee earners told us how they would put time and effort into reassuring clients that they had a right to complain if they wanted to, and explaining that any complaint will be taken seriously and dealt with fairly. Some also mentioned using the resources we have on our website, which offers guidance on how to deal with complaints. In terms of reporting misconduct to us, we did find that most firms and fee earners were reluctant to do this. So during our visits, we took the opportunity to remind solicitors that it's important they do this so we can act where necessary to protect clients. Reporting concerns can also help us build our knowledge of the sector and keep an eye on any thematic patterns of poor behaviour. Finally, most firms told us they gave clients the opportunity to provide feedback, which is important because it helps you understand things from a client's perspective and, where necessary, allows you to improve processes and procedures. So that gives you a snapshot of our thematic review, what we expect firms and solicitors to do, along with some examples of good practice. In terms of further information and resources, within our thematic report, as well as the findings, we also have checklists and a case study on complaints. And I would encourage firms to use these to help them understand how to meet our regulatory requirements and maintain professional standards. We also have on our website specific guidance aimed at immigration practitioners, which provides support in all areas we covered in the thematic review, as well as general guidance on supervision. I'll now hand over to Tony to discuss more about our supervision guidance.
Okay, thank you, Helen, and good afternoon, everyone. So I'm going to give a brief overview of the guidance that we published in November last year on effective supervision, and this covers all areas of law. And I should start by just explaining the context of regulatory guidance. So it doesn't introduce new requirements on individuals or firms. Its purpose is to help the solicitors and the firms that we regulate to understand what their obligations are and give them a sense of how to comply with the obligations. And our regulatory guidance is also something that we can use when deciding whether to take regulatory action in a particular case. So why did we develop new guidance on effective supervision last year? There were two main reasons. One is that the concept of supervising and supervising effectively runs through our existing codes of conduct. So solicitors are already required to, they're effectively accountable for the work that they supervise, and firms are required to have effective systems in place to supervise the matters that they carry out. So we wanted to give firms and individuals a really clear sense of what we thought effective supervision means in the context of providing legal services, and help them understand what our expectations are. And the second reason was that some areas of law have particular legal and regulatory requirements. So Helen's mentioned the requirements around immigration work, which are statutory. There are also particular requirements for work like claims management and for some reserved legal activities. So again, we wanted to bring together that information so that everyone could understand what it means and what we think compliance with it involves. So I would encourage anyone who hasn't to have a look at the guidance. You can see the link to it there, or you can search for supervision guidance on the SRA website. There's a lot of information in there. It includes some really useful good practice recommendations that we've heard from firms. But I'm just going to talk quite briefly about some of the key themes that the guidance sets out, and we've highlighted some of those on the slide. So the first is that when firms are deciding on what supervision arrangements to make, so who should supervise work and what they should do, how many people they should supervise, it's important to take a risk-based approach. And in the guidance, we've set out several risk factors that you can consider, which include things like the risk for clients or others if work turns out to be defective, the circumstances of clients, which includes whether they are vulnerable, the nature of the work being done, for instance, whether it involves exercising a high degree of judgment, and of course the competence of the people who are carrying out the work. So there's a longer list of risk factors in the guidance, and we'd expect firms to be able to show that they've looked at those when deciding how to supervise work. A second key theme we've set out in the guidance is that everyone who's supervising staff carrying out legal services should have enough direct contact with each of those people to provide clear oversight of the work at each key stage, to make sure that they're available to support the people doing the work where they need help, and also to provide robust assurance that the work is meeting legal and regulatory requirements. And the third key point we've set out is that just putting arrangements in place on its own isn't enough. It's also important to make sure that those arrangements are working. So we expect firms to be able to evidence what arrangements they've made. Helen's mentioned some of the findings of the thematic review relating to that. And we also expect them to take steps if it appears that supervision isn't actually delivering what it needs to do. So the immigration guidance that was published alongside our general supervision guidance in November last year goes into a little more detail about what some of these themes mean for immigration work. So I'll just touch very briefly on a couple of those points. The first is going back to the idea of applying a risk-based approach. So it's important to bear in mind the challenges that immigration and asylum clients can face, which can include, for instance, language barriers or lack of resources, and also to be aware of the severe consequences that they could suffer if work turns out to be defective. And those are factors we'd expect people to bear in mind when making their supervision arrangements. We've said in particular that where work is particularly high risk, for instance, in areas like asylum claims, it may well be reasonable for a supervisor to have some awareness of every file that the people they're supervising is working on. Another important point we've made is that if you're supervising immigration work in an organisation that's regulated by another approved regulator or by the OISC, then you need to make sure that you understand and that you comply with their requirements on supervision. And a related point, we've said that you should ensure that if you or the organisation you work in is supervising people who are doing immigration work, then you should check the regulatory history of those people. And for instance, that could involve checking whether they've been sanctioned by another regulator. And if so, making sure that you've made arrangements to manage any risks that flow from that. So I've mentioned the OISC a couple of times there, which is my cue to hand over to Deirdre to talk about their approach to supervision and immigration.
Thanks, Tony. So as Tony's just mentioned, I'm going to dive a little bit deeper into OISC supervision, just give you a bit of an idea of what that looks like, and also look at regulatory compliance, and probably focusing quite negatively on kind of themes that we found through our audits and complaints of where regulatory compliance isn't maybe what it should be. And I think what you'll see through this is there's quite a lot of synergy in the kind of issues being raised in terms of both supervision and regulatory compliance with the findings of the SRA's thematic review. So having a look at supervision, first of all. So OISC supervision is about the supervision of trainee advisors and regulated advisors, which allows people who are either not regulated to undertake some work, or people who are OISC at a certain level to work up a level under supervision. So, and it's a very sort of prescriptive set of requirements that we have. It's quite tightly controlled. So say there's a number of things you need to do to be aware of if you're working under OISC supervision. The first is that it allows work to be conducted only one level above the current level of authorization. So if you've got a trainee advisor who's not regulated at all, they can work under supervision, but only up to level 1. If they're already regulated level 2, they could work up supervision to level 3, and so on. The supervision arrangements must be authorised by the OISC in advance of the supervision beginning. There's an actual application form that has to be made, including details of the trainee and supervisor, so we would have those on our records then. And a supervision plan has to be submitted to the OISC for approval, setting out exactly how the supervision is going to work. So to say, it's quite prescriptive and quite managed. The individual supervisor must have at least 2 years recent and continuous relevant experience of either immigration or asylum work, depending on what area they want to work. The individual supervisor must be readily accessible to the supervisee. And so again, as Helen mentioned, these issues of remoteness and how do you ensure it's effective supervision, we also look at those kind of issues. There's a requirement to review some of the supervisee's client files every month. And there's a requirement to maintain a logbook related to supervision with records of the feedback given and any action required by the supervisee. And there is an expectation that the supervisee will apply for registration in their own right with the OISC within 12 months. So it's not the case you can stay as a supervisee for years and years. The idea is that after 12 months, you would apply to either become regulated or to move up to the level that you wish to be at. And the supervision arrangements are checked by us when we carry out premises audits, and sometimes they'll be looked at whenever the supervisee is applying for regulation. And that leads me kind of nicely on to our regulatory compliance and having a look at the requirements that OISC have and the codes that most often people breach. So as I say, we carry out premises audits and we've done some thematic reviews and we have investigate complaints. And from those kind of 3 tools, we've identified some of our codes which are most often breached. So it's a little bit negative, but look at kind of the themes that come up there. As I say, I think you'll see some synergy with some of the issues that the thematic review thought needed some attention as well. So the OISC codes are quite prescriptive, but as I say, these are the kind of themes that come up as the areas where advisors most often are in breach. The first is around diligence and client care. The second is around poor record keeping. And the third is around competence, in particular, sort of a failure to keep up to date, and that's often linked to an underinvestment in CPD. So looking at that first one, diligence and client care, the OISC says very prescriptive code, particularly around the initial engagement with the client and the client care letter. There are codes which require all advisors to issue a prospective client with a client care letter. They have to take reasonable steps to ensure the client understands the letter and agrees to it. And it's quite prescriptive about what has to be in that letter. And you can see there's kind of a long list there of the client details, the history, the status, the immigration instructions, the advice, the action agreed, and the confirmation of fees estimated or agreed. So it's quite prescriptive about the requirements of that client care letter. What we found is that most organisations do issue a client care letter, and there was good levels of compliance on that. But the areas of weaknesses tended to be that there's a lack of detail about the client's circumstances, that it's not captured fully in the client care letter. There's taking of insufficient instructions, a lack of clarity on what initial advice is actually given, and the use of templates that don't sufficiently pertain to the individual circumstances. And that's a really obvious one you can see when it's being used, Doug. Insufficient discussion of the merits of the case, and a failure to ensure the client understands the letter. So those, I say, are the kind of where people fall down and breach our client care requirements under the client care letter. Those are the areas in which we find that the breaches sort of focus. Moving on then to client care and poor record keeping. And again, there is a link there because often people will say, well, the client did understand all this and we did discuss it, but there's no evidence of it. And again, we have requirements to keep clients informed as the matter progresses. And we have requirements that the client is issued with a closing statement. There's requirements to have and maintain an adequate record of all interactions with the client and prospective clients. So when we have a complaint, we should be able to see detailed on the file, all those kind of, not just in the client care letter, but the advice you've given and the instructions that have been taken and so on. And there's a requirement to issue written receipts for money taken and to keep accurate accounts and a record of transactions. And as I said, going on to find where we find the breaches in these areas is often poor quality attendance notes. So attendance notes are normally there, but they're not detailed enough. And there's often there can be an ineffective case management system resulting in an inability to evidence compliance. So again, it's very likely advisors do have these discussions with clients, but the attendance notes don't reflect them. They're just not detailed enough to give that kind of reassurance to us that the client has been informed of the situation and given the right advice. Closure letters are often issued. Again, they're rarely not issued, but they often lack sufficient detail, particularly regarding the client's documents, what's been returned, and final financial statements. And that can leave the client in a position of not really knowing what their position is. Financial records can be unclear. There can often be a lack of invoices and receipts, with sometimes the temptation to issue either an invoice or a receipt, whereas really obviously you need invoices and receipts. So again, sometimes those financial records are not clear enough to avoid advisors being found to breach in that area. And lastly, going on to competence. So competence in CPD, under our code of standards, there's a requirement to act competently and maintain competence, to act only within the level of authorization that you've been granted, and not permit yourself to be used in any deception or abuse of the UK immigration procedure. And again, finding going on to the kind of code breaches that we find around those areas, again, failure to consider the most appropriate route and explain carefully the requirements of this route to the client. So the idea being that sometimes we find people are pursuing routes that just it's never going to work for the client, and so that would be clearly a competence concern. Failure to sufficiently address deficiencies in the client's application or documentation, either with the client directly or with the Home Office, particularly around things like missed dates, that need to add that detail in and to take instruction from the client as the reasons for those kind of issues occurring. Again, use of template cover letters that are poorly applied, standard template letter be put along with an application that doesn't deal with these kind of issues. A failure to properly navigate the rules in complex areas. So again, it's not that people don't know their area of immigration law, but some areas of immigration law take some serious navigation, like for example, Appendix EU and the sort of exceptions to the exceptions and the need to work through the rules and to really follow those through, particularly in areas that are changing all the time. So again, the idea of if it's not that people don't know this stuff, but it's keeping up to date and being aware of where those changes have happened and following those routes through. And I say often when we see competence issues, we'll then ask about CPD and look for those CPD records. And what we can see is a fairly direct correlation between an underinvestment in sometimes just time to study and to catch up and to keep up to date, as opposed to no CPD at all. But it's about identifying the right areas of CPD and the right areas that need very constant attention. So that seems a wee bit negative, but that's kind of an overview of the kind of OISC findings of where people are in breach or where there's areas that we think that's where our advisors, need to improve in the round. I will pass on to Julie, who's going to take on the next section, and I will take questions in the panel section at the end if there's anything you'd like to ask me about those slides.
Thank you, Deirdre. And you mentioned a couple of things that fill all immigration lawyers with fear, I think, which is missed dates, which is always something that keeps me awake at night, as well as talking about just generally dealing with very complex cases like Appendix EU or Appendix FM, which is always really difficult to navigate. So my presentation is just briefly to run through some of the things that we do within my firm, and I know that other members of ILPA have introduced into their firm in order to deal with some of these issues. So first, having a look at quality of service. So we always start with initial consultations with clients, whether that is individual clients or the organisation, but we always meet with them in order to assess strengths and weaknesses so that the client can provide us with their full instructions, and we're then able to confirm exactly what we think the merits of the case are, and we then confirm that within the written documents that we send to them. So we always send a letter of engagement and the terms of engagement to the client, and we'll always cover their instructions as well as an assessment of the case, the merits, and everything else from there. Whenever we're dealing with a client's case, no matter what the client's case is, we'll always send to them the application form, the letter of representation, and Home Office correspondence so that they're able to see exactly what we're doing and they're able to see what we're representing on their behalf so that there is full transparency at every point in their case. And so if there is something that perhaps we've misunderstood, the client can then correct it as well, and they feel totally involved in everything that they do. In terms of what we do internally within the firm, we always monitor the workload that each individual solicitor and lawyer is dealing with. And we have a number of different systems to track matters and cases. Deadlines and missed dates are really one thing that fill us all with fear. And so we make sure that we have centralized diaries, just as we'd suggest the same to clients, actually, when they're perhaps having to comply with sponsorship or whatever it may be. So we make sure that any deadlines are diarized and that those are visible to everybody within the department so that that can be covered. And then in terms of making sure that we're up to date, we always make sure that we are attending different training sessions. And this is my plug for ILPA, being a trustee of ILPA. But ILPA offers a number of free courses, as well as having a Google group, which everybody who is a member has the right to be part of. And you can raise queries with the Google group. We also have lots of connections to other services like the Ukraine Advice Service. And there are other services out there, for example, Free Movement, where you can keep up to date with immigration law, and you're able to ensure that you are fully versed in all of the changes that are taking place within immigration law, which we know are regular changes. So moving on to supervision. In terms of supervision, it is really important, particularly where you have got less experienced members of your team coming through. And it is really important those less experienced members do also get exposure to more complex cases so that they're able to learn and get experience of more complex immigration matters. And so within our firm, we do make sure that everybody works within big matters together. Different firms have different systems in place, and I know that some individuals may be allocated onto a particular type of matter, and that's what they work on. To ensure that there is consistency of service and to ensure that there is sufficient development for everybody, we do make sure that everybody works within cases. And so because there's different people working on cases, it does mean that we share learning as well. We have regular catch-ups for all of the individuals that I supervise. I have one-to-ones, and that gives them an opportunity to talk through any individual matters that they're really struggling with, and again to talk about anything that's gone really well, so that we can look at how we can develop well and progress with matters. A really interesting one here is office working. So I do meet with my team in the office as often as we can. We do also work in a hybrid fashion. So we do work from home as well. I'm working from home today. There are different systems that we've put in place because of the amount of remote working, and it is really important from my perspective that supervision still takes place, whether it's remote or in the office. But there are conversations that can take place in the office which perhaps are not always as easy if you're working remotely, and you are able to hear how people are getting on with cases. And again, more junior members of the team are able to pick things up from you when working in the office next to you. And then we do look at balancing supervision with personal development. So we do make sure that we've got peer-to-peer reviews that are taking place, so that individuals are able to support one another, as well as just supervision from the top down. And then also this relates then to complaints and how we deal with complaints. The main area of complaints in our experience is around fees and lack of transparency around fees. And so we do make sure that we have very clear and very concise ways of presenting fees to clients so that they understand that there are different fixed fees as well as hourly rates, and so that they have a choice in the different fees that are offered. One of the very interesting things that we have developed over the last few years is a fee tracker, so that individuals who have chosen to pursue an hourly rates case can see where they are next to the quote. So we can break their case down into different stages. For example, if it's a spouse visa, we would break it down into stages, and we would demonstrate how much it normally costs on an hourly rates basis, and then plot their individual matter along that tracker. And it really helps clients to understand exactly where they are in relation to fees, and then there's complete transparency. There's no confusion as to how much money may be left in order for them to finish their case, and they know where they are in the stage of their matter. And then finally, in relation to complaints, we do have feedback forms so that clients are able to tell us exactly what they think and how we might be able to improve in the future. And of course, sometimes you get some nice praise, which is always a good thing to receive as well. So that was a very brief run through from me, but I think we now move on to the Q&A.
That's wonderful. Thank you, Julie. And thanks to all of the panel there. There's been some really great insights. We've had some questions that have been coming in. So we've got a bit of time now just to run through a few of those and get some views from everybody on the webinar today. So I'll just start with a question that we've had through, which I think would be directed to you, Deirdre, if that's okay. So we've had a question in from somebody working in an OISC regulated organisation, and they're asking about trainee solicitors who are within the organisation and how they might develop practical experience without necessarily having to pass the OISC exams, and whether there's any sort of particular steers perhaps that we might have for them.
Yeah, so happy to take that, Richard. So I think we've talked a little bit about supervision, and that's obviously a key way to be able to work at a level before you're authorised properly to do it. But I do recognise that you're only allowed to work up one level. So a trainee solicitor who's maybe not regulated at all would only be able to do level 1 work under supervision. And I think what we would look at in those circumstances is you'd be looking at a mixture of things, wouldn't you? Be looking at actual training that you could undertake, as well as supervision to allow you to work up to level 1, and potentially you could also be looking at shadowing. And shadowing is a really useful way to be able to sit alongside cases and see them, see the operation of them. So when we talk about supervision under the OISC scheme, we're literally talking about you being allowed to do this work even though you're not qualified yet to do it. So shadowing, on the other hand, means you're just involved in the cases. You can certainly be helping out the regulated advisor or the solicitor do the work and gain an experience that way. So a combination of those three things is probably how you would gain the sort of relevant experience. And I think one of the things that's often confused is what you need to have in order to apply to the OISC to take the exam and to actually register at level 3. And although our competence statement for advisors does set out some suggested levels of experience, it's not set in stone. If you can show that you've been working in an area, you've perhaps working under level 1 supervision, you're doing relevant shadowing, you're attending training courses that are relevant and up to date, you're joining the types of organizations that are going to give you those updates, and you're keeping on top of things, then we would probably put you forward for testing. Like there's no set sort of experience and training you have to have. They're suggested, and what we don't want is people applying to us who've got nowhere near that kind of level of experience they'd need, but it is a suggestion. So you can put in your application form what you've done, and if we think it's sufficient, we will put you through to, for example, assessment at level 3 straight away, if that's what you think you're ready for.
That's wonderful. Thanks, Deirdre. And actually, if there's specific follow-up questions on that one, is there an easy way to contact the OISC with specific queries and things like that?
Yeah, I think if there's any queries about how to become regulated, I mean, our email address is info@oisc.gov.uk, and we certainly have an applications team that are interested in encouraging people to get regulated. And we're all very aware that there is a real need for immigration advice out there. There's parts of the country where it's almost impossible to get higher level advice. So we want people to get regulated, and we want them to get regulated at higher levels so they can meet that need. So if you're not sure and you want to ask us something, if you drop us an email to that email address, we'll try and get somebody to come back to you, or possibly give you a call, and happy to discuss with anybody who's unsure. What I'd say is, don't think I've got to meet these requirements before I come near the OISC. I'd say talk to us, and then we can see what we can do. And there's all kinds of different things we can set up, and we can certainly give you advice on.
Wonderful. Thanks, Deirdre. That's brilliant. Okay, that's lovely. So we'll move to another question we've had in, and this builds actually on the subject of supervision, and we've given some good thought to that already. I wonder if I could ask Julie actually. So we've had a question in relating to supervision across sort of multiple branches, and I guess the practical ways that people can deliver that in terms of providing immigration advice. Have you got any steers or pointers or sort of insights in terms of things that you might have seen in terms of what works well to supervise across more than one branch?
Yeah, I do think it's useful to become really organised with your supervision if you're based in different branches and you can't get to individuals in those branches. Um, it is what so many firms are now relying on in terms of remote working and setting up regular one-to-ones where you're able to just discuss cases, talk about what's working well, what's not working so well. You can do that in groups, but you can also do that with individuals. And I would suggest that you do it in both. So my team is spread across a number of different offices nationally, and we meet regularly in order to talk about our caseloads and what's actually happening with matters, and talk about how they're progressing. But I also meet with my team individually at least once a week so that we can run through anything they may be struggling with and just talk about how they're progressing more generally. So I think actually in our new world of remote working, we're set up really well for people who are working in separate branches to have more and more support, and it's a lot easier to do it now.
Brilliant. Thanks, Julie. And I wonder if I could ask Tony actually on that one as well, in terms of guidance that the SRA has put out. Are there any sort of things that you might think to recommend people take a look at if they're interested in understanding how immigration advice can be supervised across more than one branch?
Yeah, I think it comes back to the point I was making earlier, Richard, about taking the risk-based approach. So if you're looking at work being done in a branch, I think we'd expect people to look at what's the nature of the work, what are the risks involved in it, what's the experience of the people doing the work, and who's available in the branch or outside the branch to supervise it. So obviously the firm as a whole will be responsible for ensuring that it's got effective systems to supervise. We have sort of obviously recognised, as Julie was saying, that remote working and agile working is a fact of life now. And where we've said in the guidance that we think there needs to be direct contact between supervisors and the people they're supervising, that doesn't necessarily have to mean face-to-face. It can be virtual. Obviously, everyone's now very used to working virtually, and supervision can be run effectively in that way. But also, as Julie was saying, there are real advantages in doing things face-to-face in some situations. And again, we've recognised that in the guidance. I would say actually the guidance has got some really good practice advice from firms around agile and remote working in particular. So again, I'd recommend that people have a look at that.
Great. Thank you, Tony. Okay, so we just have a couple of minutes left just for our final question. So I wondered actually, we had a question through in terms of compliance with regulatory requirements. I know we've talked about supervision, but there might be sort of other considerations there. And I wondered, Julie, if you'd got any sort of off the top of your head, any views about how people can make sure if they're providing immigration advice or indeed supervising that, how to make sure that they are also keeping one eye on any regulatory requirements as well, sort of more broadly.
Oh, I think as a qualified solicitor, we're always conscious of the regulations and what we should be doing, and if we're giving immigration advice, then it's absolutely key. We're all very aware that so many immigration clients can be vulnerable, and so it's essential that we are absolutely acting in accordance with regulatory requirements. My firm, we have different systems in place so that we're staying up to date with regulatory requirements, and we do have somebody who's in charge of making sure that everything we do is adhering to the latest guidance. And I do think whilst that's more difficult for really small firms, I do think that it is important. Again, for immigration lawyers, often it may be a sole practitioner or just a very small high street firm. And I think being part of an organisation like ILPA, where ILPA has both solicitors and OISC accredited lawyers within it, we are able to share good practice and we're able to talk about and discuss the latest regulatory requirements. And I think that's really, really useful for lawyers who perhaps can't discuss it with a bigger team.
Thanks, Julie. And ILPA can be contacted. It's through ILPA's website. Is that right? Is that the best way to?
Yeah, that's absolutely right. Yeah. And in terms of just raising individual queries, we have the Google group where we can just share with peers.
Okay, wonderful. Thank you so much. And with that, I think we're probably about at the end of our slot for questions from the floor. Actually, apologies if anybody's tried to submit anything through the Q&A link, if that wasn't working for you. We've mentioned there some of the ways that you can continue getting in touch with all three organisations actually in any event. So if there are any particular queries or follow-up points that you have, we'd be delighted to continue the conversation with you in any event. We'd be really interested to know as well what you thought about the webinar today, whether the areas that we've covered were about right for you, or indeed if there's anything else that you think we could cover in future webinars. There should be an evaluation link beneath the video stream. If you have a moment just to complete that for us, we would be really grateful. It helps us to make sure that any future webinars like this, that we can target those and get the right kinds of subjects in place. And please do also share the link to the webinar with any of your colleagues, or as widely as you like, directly from the YouTube channel. And just to close off, to mention that some of the resources that we've covered today, you can find those actually on the SRA's website. You can just look for immigration services or search for that at sra.org.uk, and you'll easily find those. And with that, it's just down to me to say a big thank you to everybody who's taken part and been on our panel today. We're really grateful, and also to everybody who's taken the time to send questions through to us, and also who's watched the broadcast today. So thank you very much.